Hello everybody, Andrew Reed here from Victoria, BC, coming to you with this next part of my study guide on the NCA exam for constitutional law. Part 11, the application of the Canadian Charter of Rights and Freedoms. So I'm just following along with the syllabus provided by the NCA for 2023, just case briefing the hyperlinks and that are contained in that syllabus. Okay, so let's go ahead and get started. We got the application of charter directly quoted from the Constitution. This charter applies to the Parliament and Government of Canada in respect to all matters within the authority of Parliament, including all matters related to the territories, and to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. So what does this mean? A lot of background is given to us in Eldridge versus British Columbia. Now this case also goes through a Section 15 analysis as well, which is equality, which I have included in here as well. So I'll share that with you, even though that's not in this part of the syllabus yet. But I just felt that actual analysis may be very useful for certain questions, at least for me, in the exam itself. So Eldridge v. British Columbia. Some issues here. Whether the definition of benefits infringed Section 15(1) by failing to include medical interpreter services for the deaf. And if it did infringe it, whether those impugned provisions were saved under a Section 1 analysis from the Charter. More on that later. And then whether some other sections infringed Section 15(1) by failing to require that hospitals provide medical interpreter services for the deaf. And if that answer is yes, whether those impugned provisions were saved by Section 1. Also at issue was whether and how the Charter applies to the decision not to provide sign language interpreters for the deaf as part of the publicly funded scheme for the provision of medical care. And if there were a Charter violation found, what the appropriate remedy would be. So this actually delves into quite a lot beyond just whether the Charter applies. So I've briefed this case relatively in full. But again, that's beyond the scope of this section of the syllabus, so keep that in mind. Background here, medical care in British Columbia is delivered through two primary mechanisms, and neither of those programs pays for sign language interpretation for the deaf. In this case, each of the applicants was born deaf, and the preferred means of communication was sign language. And they were saying that the absence of having interpreters impairs their ability to communicate with their doctors and increases the risk of misdiagnosis and bad treatment. So the appellants unsuccessfully sought a declaration immediately from the Supreme Court of British Columbia that the failure to provide sign language interpreters as an insured benefit violates Section 15(1). So a majority of the Court of Appeal dismissed an appeal for this judgment. So 0 for 2. But here at the Supreme Court of Canada, they said the appeal should be allowed and that the first and third constitutional questions were answered in the negative, therefore it wasn't necessary to do a Section 1 analysis. So in this case, some rules that came from this case. The Charter applies only to the Parliament, the provincial legislators, and entities that constitute part of the executive or administrative branches of government, and not to private activity. This is from Dolphin Delivery. Section 15(1) itself says, every individual is equal before and under the law, and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, origin, color, religion, sex, age, mental or physical disability. And next rule, a person claiming a violation of Section 15 must first establish that because of a distinction drawn between the claimant and others, the claimant has been denied equal protection or equal benefit of the law. And secondly, the claimant must show that the denial constitutes discrimination on the basis of one of the enumerated grounds listed in Section 15 or one that's analogous to that. This is from Eaton versus Brant County Board of Education. Next rule, Section 15(1) will not be infringed unless the distinguished personal characteristic is irrelevant to the functional values underlying the law, provided that those values are not themselves discriminatory. That is from the Myron case, which is quoted quite a lot. every difference in treatment between individuals under the law would not necessarily result in inequality, and as well, that identical treatment may frequently produce serious inequality from Big M Drug Mart. Section 15.1 was intended to ensure a measure of substantive and not merely formal equality. So they want real equality, according to Big M. A government may be required to take positive steps. That means it's some form of actual action to ensure the equality of people or groups who come within the scope of Section 15. This is from Hague. So the analysis here, first, whether or not the Charter applies. The Charter applies to provincial legislation in two ways. Firstly, legislation may be found to be unconstitutional on its face because it violates a charter right and is not saved by Section 1. Secondly, the charter may be infringed not by the legislation itself, but by the actions of a delegated decision maker in applying it. The legislation remains valid, but a remedy for the unconstitutional action may be sought pursuant to Section 24 of the Charter. So, breaking this down into analysis. It is first necessary to decide whether the legislation impugned in the present appeal can be interpreted in conformity with the Charter. So he's saying both statutes could be read to conform with Section 15. Under this theory, it's not the legislation that is suspect, but rather the actions of the decision makers in applying it. And that with the exception of hospitals, which are the responsibility of the provinces, by virtue of Section 92.7, the heads of power is saying that hospitals are provinces, health is not a matter assigned solely to one level of government. And then hospital insurance and medical care problems come within the heads of powers of Section 92.7 hospitals, Section 92.13 property and civil rights, and 92.16 matters of a merely local or private nature. So he is breaking this down into the heads of powers. Provision of medical treatment by doctors and other healthcare practitioners in British Columbia was governed by the Medical and Healthcare Services Act at the time, and the legislation does not specify the benefits it provides. So it does expressly say that certain services are not insured, and sign language interpretation is not included on that list of what's not insured. So the determination of what constitutes a benefit is left to the discretion of the commission, a 9-member panel that was created to decide such things. So the failure to provide expressly for the sign language interpretation does not constitute a Section 15.1 violation. The Act does not list those services that are to be considered benefits. Instead, it delegates the power to make that determination to a subordinate authority. In that case, then, if the authority doesn't include it, it's their actions that would be constitutionally suspect, not the statute itself, according to this judge. So, while hospitals may be autonomous in their day-to-day operations, they act as agents of the government in providing the specific medical services set out in this Act. And so, in this way, the legislature cannot evade its obligations under Section 15.1 to provide services without discrimination just by appointing an independent, autonomous place to carry out the objective. And as far as they employ that autonomous third-party actor, then that third-party actor, in this case hospitals, must conform with the Charter. So having concluded that the Charter applies to the failure of hospitals and medical services commission to provide those sign language interpreters, then the question is, it remains to be determined whether that failure infringes the appellant's equality rights under Section 15.1. So in terms of the NCAA syllabus, you could stop right here and then you'll have basically what they wanted you to get. I wanted to include this Section 15.1 analysis because I feel like this will be useful information for my own personal study guide. So continuing then, Section 15.1, like other charter rights, is to be generously and purposefully interpreted from Big M Drug Mart. As deaf persons, those appellants belong to an actual enumerated group under Section 15.1, the physically disabled. From the case Turpin, the determination of whether a law is discriminatory is a contextual exercise. You don't just look only at the legislation, but also to the larger social, political, and legal context. The distinction here is based on a personal characteristic that is irrelevant to the functional values underlying the healthcare system. So these values consist of the promotion of health and the prevention and treatment of illness and disease. That's why they build hospitals and made this act. And so the realization of those values through the vehicle of a publicly funded healthcare system. There could be no personal characteristic less relevant to those values than an individual's physical disability, therefore passing this test. So since that test is passed, then the only remaining question is whether the appellants have been afforded equal benefit of the law without discrimination within the meaning of Section 15.1 of the Charter. So both deaf and hearing persons are entitled to receive certain medical services free of charge, especially in British Columbia. The appellants nevertheless contend that the lack of funding for sign language interpreters renders them unable to benefit from this legislation to the same extent as somebody who can hear. So they're saying that their claim is one of adverse effects discrimination. So this is a consequence, perhaps unforeseen, of not having this inclusion of the sign language interpreters. So the judge goes on to say a discriminatory purpose or intention is not a necessary condition of a Section 15.1. So it doesn't have to be intentional or motivated by a desire to disadvantage an individual or group in order to violate Section 15.1. Interesting side note, it does have to be like that in the United States, to the extent of my knowledge from coming from that area. Anyway, it is sufficient if the effect of the legislation is to deny someone the equal protection or benefit of the law. Therefore, an adverse effect is sufficient to be considered discrimination or a possible Section 15.1 violation. In the case Simpson-Sears, the court was faced with the question of whether a rule requiring employees to be available for work on Friday and Saturdays discriminated against those observing a Saturday Sabbath. And so, although this rule is neutral on its face because it applied equally to all employees, the court in that case found it to be discriminatory. So you can see they're taking cases with somewhat similar fact patterns and analyzing in comparison. In the present case, the adverse effects suffered by deaf persons stem not from the imposition of a burden not faced by the mainstream population, but rather from a failure to ensure that they benefit equally from a service offered to everyone. Effective communication is quite obviously an integral part of the provision of medical services. At trial, the appellants presented evidence that miscommunication can lead to misdiagnosis or a failure to follow a recommended treatment. The court, and this court, has repeatedly held that once the state does provide a benefit, it is obliged to do so in a non-discriminatory manner. In many circumstances, this will require the governments to take positive action. For example, extending the scope of a benefit to a previously excluded class of persons. So, in conclusion here, the failure of the Medical Services Commission and hospitals to provide that positive sign language interpretation where it's necessary for effective communication is a violation of Section 15.1. And this failure denies them the equal benefit of the law and discriminates against them in comparison with hearing persons. So not only does the charter apply, but here in this case they have a clear violation of Section 15. But when you violate a constitutional right or charter right here, then you then go on to see whether that right is saved by Section 1, which is, in order to justify a limitation of a charter right, the government must establish the limit is prescribed by law and is reasonable in a free and democratic society. So this comes from the Oakes case and is known as the Oakes test. A lot more on that later. So I've copied the analysis here just because always good to have one more Oakes test in the mix. The failure to fund sign language interpretation is not a minimal impairment of the Section 15 rights of deaf persons to equal benefit of the law. They're like, it's a major impairment. Deaf persons receive medical services that are inferior to those received by the hearing population. And given the importance of good health and the quality of life of all persons in our society, then provision of substandard medical service to the deaf diminishes the quality of their lives. So the government who's arguing against this has not demonstrated that this must be tolerated in order to achieve the objective of limiting healthcare expenditures. Stated differently, the government has not made a reasonable accommodation of the appellant's disability here. So in the language of the court's human rights jurisprudence, it has not accommodated the appellant's needs to the point of undue hardship from the Simpson-Sears case. In the present case, the appropriate and just remedy then is to grant a declaration that this failure is unconstitutional and to direct the government of British Columbia to administer the Medical and Healthcare Services Act in a manner consistent with the requirements of Section 15. So this remedy was a declaration as opposed to an injunctive relief. Good to know these remedies, but a lot more on this later, so I won't go any further. The final case in Part 11 here, under whether the charter applies, is from Greater Vancouver Transportation Authority. And this one I just narrowed down, also a great case, but I just narrowed it down to the paragraphs in the syllabus, which says some points from those. The charter applies not only to Parliament, but the legislators in the government themselves, but also to all matters within the authority of those entities. There are two ways to determine whether the charter applies to an entity's activities test. So by inquiring into the nature of the entity or by inquiring into the nature of its activities. If the entity is found to be government, either because of its very nature, because the government exercises substantial control over it, then all of its activities will be subject to the charter. If an entity is not itself a government entity, but nevertheless performs governmental activities, only those activities which can be said to be governmental in nature will be subject to the charter. So their analysis here as to why TransLink, being partly run by BC Transit and under this act that's in question in this case, the Greater Vancouver RD has substantial control over the day-to-day operations of TransLink, which, when combined with the GVRD's powers to appoint the vast majority of the members of TransLink's board of directors, satisfies the control test posited by the authorities. So to the extent that the GVRD does not have complete control over TransLink, they share that control with another entity that's under the charter, the provincial government. In either case, the judge concluded that the TransLink cannot be viewed to be operating independently or autonomously in a manner similar to either universities or hospitals. It's no independent agenda other than that provided by its Constituent Act, and no history of being an entity independent of government. It is substantially controlled by a local government entity and is therefore itself a government entity. So concludes Part 11 of this study guide. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.